an event that is sponsored by the Latin American and Caribbean Center, in particular by the Latin American and Caribbean Center Andean Studies Program, which is a new program that we are very proud to be working with. It is also co-sponsored by the College of Law and by the Václav Havel Initiative for Human Rights and Diplomacy, that is an important component of our School of Public and International Affairs. My name is Victor Uribe. I am a professor and chairman of the Department of History here at FIU, and I will just have the function of serving as a facilitator to this activity. The main speakers in this event are going to be Viviana Krsticevic. I hope I pronounce her name correctly. Manuel Gomez, Ana Maria Bidegain, and Gianfranco Patuzzo. I will make a brief introduction and pay close attention to Viviana Krsticevic. The other introductions are going to be much briefer because we know our colleagues here from FIU, but we do wish to highlight some of the activities and accomplishments of Ms. Krsticevic, whom we are very pleased to host here at FIU and whom we welcome warmly. Viviana Krsticevic is the executive director of the Center for Justice and International Law, CEGIL. CEGIL is a regional non-governmental and non-profit human rights organization. This organization works to ensure the full implementation of international human rights norms within the member states of the Organization of American States, OAS. They use the Inter-American System for the Protection of Human Rights. And in her capacity as director of CEGIL, Ms. Krsticevic has litigated numerous cases in defense of victims of human rights violations, both before the Inter-American Commission and the Inter-American Court of Human Rights. She has presented numerous conferences and workshops in the Americas and Europe on issues pertaining to international protection of human rights. She was born in Argentina, received her law degree from the Universidad de Buenos Aires, Argentina, her master's degree in Latin American Studies from Stanford University, and her LLM from Harvard University. She has published various articles on human rights at an international level, particularly about the Inter-American system. These articles have been published in the US, Latin American, and Europe, and again, we are very pleased to have you here at FIU. I will introduce briefly the rest of the speakers so that I don't have to interrupt the proceedings, and once Ms. Krsticevic makes her presentation, we will proceed with brief comments by Professor Manuel Gomez, Professor Ana Maria Bidegain, and our MA student, Gianfranco Patuzzo. Manuel Gomez has many years of law teaching experience, both in the US and in Latin America, and has also years of professional practice in Latin America. He currently serves as the College of Law's coordinator of international legal projects and leads the Global Legal Studies Initiative. He has published numerous articles, and his fields of expertise are the impact of social networks on dispute processing, private order, international arbitration, the nature of complex litigation in Latin America, legal and institutional reform in Latin America, legal education reform, and globalization and the legal profession. Ana Maria Bidegain is a professor of religious studies. Her areas of specialization include Christianity in Latin America, women in Latin American religions, the history of religions in Latin America. She was born in Uruguay, studied in Uruguay and Belgium, earned her PhD at the Catholic University of Louvain, and spent many years of her career in Colombia, where she lived and taught for more than 20 years. Now she is a member of the Religious Studies Department, and again, I won't read the extensive list of her publications for the sake of time. And then we have with us a student in the MALAX program, Gianfranco Patuzzo Garcia. Both Ana Maria Bidegain and Gianfranco Patuzzo Garcia's intervention are going to be presented from the perspective of victims of human rights violations. In the case of Gianfranco Patuzzo, he happens to be the nephew of Mauricio Garcia Prieto, who was the victim of an extrajudicial assassination in El Salvador that he will tell us about. So again, we will start with Ms. Viviana Krsticevic, who is going to talk to us about the inner workings of the Inter-American Court of Justice, the Inter-American Court of Human Rights, and then we'll proceed with brief comments by Manuel Gomez, who is going to possibly address the impact of Venezuela's withdrawal from the Inter-American human rights system, a withdrawal that took place in late 2012 and became effective in October 2013. And then both Ana Maria and Gianfranco are going to speak about the perspective of the victims. I cannot highlight sufficiently the significance that human rights issues have for us, for several of us here at FIU. I hope that this is one of many more activities that we'll continue to promote to disseminate information about the significance of not only denouncing human rights violations, but also trying to work to preempt it, because unfortunately this continues to be a major challenge for not only Latin American societies, but also for the United States. So with nothing further ado, I give the floor to Viviana. And again, I welcome you once more to FIU. Thank you for having accepted our invitation.
It is really a pleasure for me to be here. I truly appreciate the kind invitation that Victor, Ana Maria, Matthew extended to me, and the opportunity to talk to you about some of the experiences of litigating cases before the Inter-American system, as well as some of the things that I think are important and interesting from an academic perspective, but also from an activist perspective for international law, for Latin American studies, and for human rights. The Inter-American Court on Human Rights, as many of you know, is one of the two protection organs that the Inter-American system is composed of. There's a Commission on Human Rights and an Inter-American Court on Human Rights. They're composed by 7 experts from different countries of the Americas. The members of the Commission are lawyers and non-lawyers. We have a journalist, a sociologist, and a group of activists and lawyers, and the members of the court are primarily lawyers. The mandate of the Inter-American Commission and the Inter-American Court of Human Rights is to promote, protect, and defend human rights in the Americas. And they do so by adjudicating cases, but also performing other functions. So the Inter-American Commission also conducts on-site visits, issues reports where they do standard setting. Those are the current members of the Inter-American Court. It's a kind of a somber picture, but there they are. The Inter-American Court initiated its work in 1979 with the coming into force of the American Convention on Human Rights. The Commission preceded the court, and the Commission works as like a first instance organ in the process of adjudicating cases. Even when the court started its work in the 80s, it didn't start to adjudicate cases more systematically until the mid-90s. The Inter-American system is designed to protect a broad range of civil and political rights, and it's about state responsibility, international state responsibility. And that in international human rights law is defined very broadly. It doesn't include only actions or omissions by the police and the military, but it also includes some of the failings of the legislative, of the judiciary in protecting human rights. The Inter-American system then, and the Inter-American Court in particular, can adjudicate cases from different countries in the Americas that have ratified the American Convention and have accepted the jurisdiction of the court, and can issue binding decisions that provide for reparations for victims, and also what is called in the language of international human rights law, measures of non-repetition, which are reparations that go beyond compensation. They include measures of satisfaction and non-repetition that can include, for example, asking a government to change its legal framework or policies, or acknowledge responsibility and ask for forgiveness for human rights victims, publish a report, and do justice. So in evaluating the work of the court in this last 3 decades since it started working, we can say that this court of last resort for human rights victims in the hemisphere has had a bittersweet record. It has not been truly a last resort for all of the human rights victims of the hemisphere. The victims of violence, discrimination, denial of justice are in the range of hundreds of millions in the region. If you think about the indigenous peoples and women subjected to domestic violence, and hundreds of thousands of people that have been affected by political violence in the region. And even by a simpler approach, if you look at those that have submitted petitions to the Inter-American Commission and the Inter-American Court, not all of them have had a timely response or a satisfactory response to the petitions that they have submitted to those organs. However, the Inter-American system and the Inter-American Court in particular have been important actors in the search for truth, accountability, equality, and the rule of law. And I think that's where the value of this court of last resort lies. This region, I believe, is better off because we had a court that at times was brave enough to provide the moral and the legal compass that could not be guaranteed by the domestic legal processes in most countries in the hemisphere. And part of the contributions of the Inter-American Court and the Inter-American system lie in 3 main areas. One of those areas is accountability. The Inter-American Court has been crucial in defining and promoting the right to truth for human rights victims and victims of gross human rights violations in the pursuit of justice. As you know, there are many structural problems, the pervasive persistence of impunity, the role of the military justice system that has been an obstacle for justice in the region. And the Inter-American Court has helped through a set of decisions to overcome and to improve the chances of justice in many countries in the region. Here is an image of some of the family members of the cases of Barrios Altos and La Cantuta in Peru that we represented. Those massacres occurred during the Fujimori government in Peru, and the family members tried to get justice at the domestic level for many years. There was an amnesty law that passed, and because of a couple of very important decisions in those cases of the Inter-American Court, the amnesty laws Peru were overturned, and a set of judicial processes were able to start engaging and involving hundreds of perpetrators of human rights violations, including former President Fujimori, that when he was eventually extradited from Chile and punished in part for his engagement in La Cantuta and Barrios Altos, amongst other cases. So with the topic of amnesty laws, you can see there's a thread of cases where the Inter-American system was the determining factor that allowed and worked synergically with some of the domestic processes in order to ensure that there was some level of accountability. That happened not only in Peru, but also in Uruguay with the Hellman case, in Brazil, which is starting late, but the search for truth and justice through the Araguaia case, as well as other cases domestically, such as the cases in Argentina that also, and I can explain this in the question and answer period, that also included a dynamic between international protection and domestic protection in the pursuit of the right to truth and justice and accountability at the domestic level. So this is one area where the Inter-American system has actually had a very strong mark, and it has shaped the history of our region. It has, with different dynamics in the different countries, but it has had an important impact. A second area that is very important is equality and non-discrimination. The Inter-American system has the privilege of having the first convention on violence against women, the Convention of Belém do Pará, and also has had a very important set of cases that have helped identify and highlight some of the problems in fighting against domestic violence, as well as it has had an important impact in the definition of the rights of indigenous peoples, the right to land, the right to culture, and it has ensured that some indigenous peoples preserve their ancestral land, and with that, the continuity of them as a people. That can be shown, for example, in the cases of Sarayaku, in some of the cases in Paraguay, like at the Shetlamenshay, Yaquiaxa. But it is also, the Inter-American system is now making inroads in the fight for equality of the LGBTI groups and persons in the region. It's actually quite bold what they are doing. They have started a rapporteurship. They are bringing that discussion to a region that is not necessarily always very open to issues of equality based on gender orientation. And the third area where I think that the Inter-American system has made an impact is the issue of the rule of law and strengthening of the democratic system. Through a set of cases, reports and actions, for example, those that surrounded the coup d'etat in Honduras, their work on the administration of justice system in Peru, in Guatemala, with the case of, with the development of jurisprudence and mechanisms for the protection of freedom of expression, the Inter-American system has made an important contribution in defining some of the pillars of the rule of law in the region. It has also been very important for human rights defenders, which I believe is like a forgotten small but important part of the fight for the rule of law in our continent. Why is the Inter-American system relevant to the history and future of our region? I think that we are at a crossroads. Our region has democracies, elected democracies that are still striving to find a balance and to strengthen the rule of law. Governments from different political leaning to the right and the left have actually challenged some of the premises of the protection of human rights and democracy. And I believe that having a regional mechanism of human rights protection can still be very important and relevant at this stage of our history as a region. It will probably not be the same role that it had during the military dictatorships or the civil conflicts in the region, but it's still a very worthwhile, important relationship. And some governments have realized that, and some of the success that the Inter-American system has had in dealing with important issues in the region and rendering binding decisions that have affected countries significantly have come at a price. So there's a price to success. And it's not only just having more cases being brought to the Inter-American system, but there have been efforts by governments from the right and the left to curtail the scope of what the system can do, the Inter-American system can do, how far they can go in terms of challenging the democratic decisions that we're taking domestically in different areas, from issues of equality to the workings of the judiciary, and how far can the Inter-American Court go in reviewing the evidence and the criteria that a domestic court used in evaluating a specific case, to the scope of reparations that are granted by the Inter-American system. Some of the new discussions challenge the premise of international human rights protection. Many governments are now saying that the Inter-American Court and the Inter-American Commission should not be open to all, but they should become like a more like a supra-constitutional court for the Americas, as if the problems that we had in the region were problems of, fine-tuning legal issues and not, the very famous do no harm, do not kill, do not torture, just render justice with equality and things like that. So there are all of these discussions that are creating a lot of tensions, and I see that there is an important space for a setting such as this one to engage more actively from different perspectives in some of the discussions that are going on. I think that there's an under-theorizing of some of the things that have to do with the relationship of international human rights law and domestic law, international on constitutional law, for example. There is an under-theorizing on issues of compliance and impact, and there are different people that have developed theories coming from varied experiences of the intersection of international relations and international law that have come with very interesting and sophisticated theories that do not match our experience in terms of what moves countries and what are the models that we use in order to get compliance at the domestic level in different circumstances. So I think that there's a whole, from a purely academic perspective, there's a huge area. There are many areas where there are interesting topics that are still open. There are many stories that have not been told in terms of the cases, in terms of, there's a lot of documentation, because one of the beauties of international litigation is that when Amnesty writes a report or Human Rights Watch writes a report, they write a report and they collect evidence and they present a beautifully written, very professional report. But when you have a case, the state and different actors within the state, they have to answer and they have to provide evidence. And so you have, I don't know, thousands of pages of a much more, I don't know, rich, interesting history that has not been told, and the impact of those synergies of the domestic and the international that have not been told. And then there are the political debates. I think there's a whole aspect of monitor, engagement, criticism that is healthy, is nourishing for the development of the system itself, for those of us that are engaged in that system, and also to counterbalance all of the pressures that the members of the commission, of the court, of the OAS have from governments that do not want scrutiny, that do not want that monitoring. And there's something to be said about what would be of so many situations and victims and groups in the region if we didn't have this type of international human rights monitoring. And if I am dissatisfied with many aspects of the workings of the system, and I have a bittersweet view of its accomplishments, I also realize in my own experience as a litigator that we would be much worse off if we didn't have this. And I think that a university and students and professors writing and looking at this can actually also make a difference in how this progresses, because I do believe that each of us has a possibility of helping change the course of history. I know that this challenges some of our professors. I remember I was in a meeting in Oxford with Professor Leslie Bethel, and I had read his books when I studied, Latin American history, and he was saying, he's an expert on Brazil, and he was telling about, the little possibilities that we had to change some of the issues of truth and justice in Brazil because of all the different dynamics that had happened historically and how Brazil had dealt with the dictatorship. But here we are, and we have a truth commission. And we have now the first cases that after 34 years are being brought by the public ministry. So I do believe that we can still, even when there are many obstacles, we can still make a big difference. And I think that now you're going to hear from Ana Maria and from Gianfranco some of the personal and political stories of what is at stake and what can we expect also from the Inter-American system. So I thank you, and I'm open to questions when we're finished. Thank you.
Manuel, I don't know if you want to come to the podium or you want to speak from where you are, and we'll have time for questions and answers at the end of the session.
And thank you. That was a very interesting and very insightful description of the work of the court and the work of the Inter-American System of Human Rights. I will address issues having to do with Venezuela, one of the most controversial members of the Inter-American System of Human Rights. It was, interestingly enough, one of the most fervent supporters of the Inter-American System of Human Rights since its inception until very recently. when primarily for political reasons, the government of Venezuela decided to withdraw or to denounce in more technical terms the Inter-American Convention on Human Rights, which took place, as Victor mentioned, on September 10 of 2012, under Article 78 of the convention. There was a wait period of a year for that denunciation to take effect, so it took effect on September 10th of 2013. I will address 4 basic points. Number one, what are the reasons that drove the government of Venezuela? And that's very informative for the future, as the case of Trinidad and Tobago, the only other member of the Organization of American States that had denounced the Inter-American Convention, had done before, and the Trinidad and Tobago case was very helpful to understand the legal boundaries of what had Venezuela done, and also from a political standpoint. So I'll talk a little bit about the reasons, what drove Venezuela to do what it did, then the effects of it, both from a technical standpoint and then from a political standpoint, and then I'll very briefly address the current situation. This is all in like 5 minutes. So what happened? Though Venezuela did not, so in a very lengthy document that was not available to the public for a little while, I wonder if it is because the OAS had not digested the scope of the document. The denunciation took place in September 10th of 2012. I was teaching international law at the time. It took me like a week to get the document. It was not available in the website, as most of these documents are available right away. A statement from the Secretary General of the OAS was available, a press release basically urging the government of Venezuela not to pursue what it had said it would pursue. So in a very lengthy document, Venezuela complained that the Inter-American system of human rights had become politicized. This came as no surprise because at least since 2008, the constitutional chamber of the Venezuelan Supreme Court, known in Venezuela as the Tribunal Supremo de Justicia, had urged the government to take steps to get out, to exit the Inter-American system of human rights, basically by stating that the system had become illegitimate. So interestingly enough, if you ever read Venezuela's the denunciation statement, the government says, we have been always observers of human rights in the Americas. We have been good players, but the court has become politicized and the commission had become politicized. And the reason for that is that the commission had issued reports repeatedly since the early 2000s that were not favorable to Venezuela. Venezuela complained that the commission didn't treat the government of Venezuela with due process and inequality of terms and so on and so forth. And it said then we're forced to get out of they didn't say we're forced to get out of the system. They say we're forced to then withdraw ourselves from the commission. And it really targeted the commission, not so much the court, which is really interesting. But in the formal sense, and this then makes me jump to number 2, in the formal sense, a withdrawal from the convention, so by saying we're not anymore parties to the convention, it would also affect the court, the jurisdiction of the court, not only the jurisdiction of the commission. So what happens? After Venezuela said we withdraw ourselves from the Inter-American Convention of Human Rights, which is a very important document, but not the only document. And necessarily, and the first reaction that people had was like, well, now Venezuelans won't enjoy the protection of the Inter-American system of human rights. Now what's going to happen? There are no ways of getting redressed. Someone had said that also goes against the Constitution of Venezuela, which in Article 31, I think, says that citizens should have the right to file their petitions against anybody, and the government should not block that. So someone said, well, that's an effective obstacle against the citizens' rights to present their petitions. But the implication was basically, well, it is a grave implication, but I'm an optimist, so I will I will show you what I think is the brighter side of this denunciation. Of course, it took effect on September 10th of 2013. What that means is that no new cases will be formally received by the Commission, and of course the Commission will not be able to recommend to the court pursuing cases against Venezuela based on circumstances or facts or events that had taken place after September 10th of 2013. However, the court and the Commission still, well, the Commission has this supervisory role, which was stated by the Commission in several reports having to do with Trinidad and Tobago. Reports from 2002, I remember two, Sheldon and Roach, were two reports that said that despite Trinidad having denounced the Inter-American Convention of Human Rights, Trinidad was still bound with regards to the court. The Commission still had a role, an important role over Trinidad, and that was a very important one. And then the court would arguably still be competent regarding prior occurrences, and there are three cases, one from 2001, Hilary, and then Benjamin and Constantine from 2012, addressing the problem with Trinidad. These are judgments by the court that had said, well, it's true that they withdrew from the convention, but that doesn't mean that they're out regarding acts that took place prior to the denunciation. Of course, there's a practical effect, which means that the state that is not a party anymore will not comply voluntarily. So you would have to exercise a number of other levels of pressure politically, mainly because you will have a non-cooperative party to whatever proceedings are there. And of course, you know, if a case moves forward, the state will always bring as an argument that they're not bound by the convention or the commission or the court, and that they will not have to cooperate with the commission or the court. Just in closing, and then we can talk a little bit more about this, what is the situation now? The situation now is that despite not being bound by the convention, Venezuelan citizens still have recourse to their internal mechanisms. Of course, then you would say, well, internal mechanisms don't work if the courts are packed by people who are allied to the government. But still, there are cases being filed routinely before Venezuelan courts. Venezuela is also still bound as a member of the Organization of American States, has not been suspended, is still bound by the Democratic Charter and other very important instruments, and also an organ or a series of organs that Venezuela recognized in its denunciation, those organs that are part of the United Nations human rights regime. In fact, the government of Venezuela put a lot of interest or a lot of real estate in its document in highlighting the importance of the United Nations mechanisms for the protection of human rights. So I guess the victims' advocates could use that to their advantage. How is it going to play out in the practice? We don't know. Certainly, this is an obstacle. It's an unfortunate event. Hopefully, the government of Venezuela will, revert their decision at some point and rejoin the convention. But so far, we have two countries that have denounced the convention. We have Trinidad for a different reason, Venezuela more recently. But then we have two very powerful players in the hemisphere who have never joined the convention, the United States and Canada. And I have jokingly would tell my students when they were frustrated about this, I say, well, then that means that Venezuelans don't have the same protection that Americans and Canadians have before the court and the commission. Thank you very much.
Having heard from a practitioner and an academic, now we want to hear from the victims. We are going to talk about a case involving violations in Colombia and another case involving violations in El Salvador. Both of these cases have been brought before the Inter-American Court of Human Rights. First, let's hear from Ana Maria Bidegain, and then we'll give the floor to Gianfranco Patuzzo.
Hi. As you know, my name is Ana Maria Bidegain. I am a professor in the Religious Studies Department. And I am also the widow of Carlos Horacio Uran, who was one of the victims of the attack to the Palace of Justice. I will read because I can go over and over, and I prefer to stay in my time. Then the date of October 6, 1985, Colombia shocked with the siege of the Palace of Justice in Bogota, an attack against the Supreme Court of Colombia, in which members of the M19 guerrillas group took over the Palace of Justice and held the Supreme Court hostage, intending to hold a trial against Presidente Belisario Betancourt. In the over 48 hours of pandemonium that followed, hour after a military raid, the incident left almost half of the 25 Supreme Court justices held captive in the palace. They were dead. Showed that in political and social intrigue, the cataclysm which occurred in the Palace of Justice over 20 years ago is not an isolated case in recent Colombian history. The state itself recognized the existence of more than 5.5 million victims of political violence. This number represents almost the 12% of the population of Colombia, forcing a horrifying reality in the country's contemporary history. As part of an effort to consolidate the much-needed peace process in Colombia, last year, the country's most important magazine of public opinion and social analysis, Semana, along with other popular media correspondents, brought together a group of relatives of the victims of the attack of the Palace of Justice and the victims of any victims all over the country, all that they call the emblematic cases. Seen as necessary yet painful effort, this convocation, though it opened many wounds that will never cease to bleed, resulted in a consensus which identified the victimized families' emotional commitment to heal and reconcile their pain and loss. The urgency in their cries for recovering produces the following implorations. That is my own systematization of more than, 500 testimony, but after the group of the people recognized as the word their own words. First is the idea that we need a consensus acknowledgement by both the society and the state that the victims and their families have a moral right to recompense for their emotional injuries caused, to be recognized, that the country needs to recognize the situation. Those these claims are painful for the families. Without this necessary complaint, there cannot be healing, and even less justice. And for us, justice starts with the victims. If the victims don't comply, there is no justice. We can have excellent system, we can have excellent lawyer, but victims need to do the first step. It is imperative that we create a space in which, within a legal framework, these appeals are supported under statutory parameters. Second, the Colombian society must embrace this pain and devastation as their own, assimilating the indignation and injustice that these families have lived with for almost 3 decades. That is for the case of the Palace of Justice, but also for everybody. For we have more than 6 decades of war. This solidarity will create a strong necessary to prevent such a history from repeating itself. with an emphasis in forbidding the interface of politicians in judicial matters. Citizens will therefore require that politicians deliver on their promises of justice and reparation, because one of the difficulties is that the politicians took the case, but never really go ahead with their own words. And they use politically the cases instead of support the justice. Third, we deserve to know the absolute truth. Through the plethora of lies, confusion, and deception, as I experienced myself and my daughters over decades, is a heartless act of inhumanity. One does not allow the heart and soul to mend. The state must advance with substantial measures to search for the truth and seek justice, especially those committed by the state servants. This quest for finding the truth is the only way to rebuild the truth, the trust that has been destroyed. In particular, it has been destroyed because many of this crime came from the state servants. Without truth, healing will never be possible. Fourth, the pain of the victims and the volume of the atrocity of all these events must become a resonating story in everyone's memory. A painful memory that yes has no explanation requires a new awareness, one that will ignite the support of other Colombian citizens, preventing such an act from repeating itself. This much needed social and political mechanisms of recollection are crucial in the healing process. And that, I think, is one of the ways that the academician can help and recover all these stories. Fifth, create an awareness that remembering is healing. Resizing and reinterpreting history helps locate bypasses evidence and disregarded facts, especially those kept alive in the memory of the victims. A sacred reality. Pedagogically, mechanisms must be developed to help the victims understand and interpret the events of the attack of the palace, but any of the cases that haven't happened, allowing them to discover for themselves explanation of what exactly happened, because of exactly happened. With the help of a skilled professional, more restorative strategy can be developed, not only to recover the past, but also to recover the future. And I think that we have the Memoria Histórica, the group of Memoria Histórica is doing a tremendous work, and I think that LAC should be much more close to this experience and more supportive. Six, it's important to understand the struggle for justice and the effort against violence that the victims were assassinated for. The reality of these struggles and the personal commitment of each of those who died in 1985, but not only at this time, and not only in Colombia, but to each citizen are essential in the healing process. I think it's important, the recovering of these stories and why these people died, and to understand their fights, because normally was related to issues related to justice and to the look of justice. And seven, to recognize that collective memory also raises civic responsibility, ones that begin with a claim to justice, reparation, and the respect for the judicial decisions made for society at all levels of governmental protocol. The Colombian society not only needs to support human rights defenders and legal representatives of the victim, as the case of the victim of the palace, but or any legal representative, but it must also demand that the state produce an efficient judicial system, an all-encompassing system that administers a unified proliferation of the truth. The presence of a unified judicial system in the case for truth and dignity will effectively diminish the perpetuation of the impunity that has allowed for the wound of those of us who were victimized by a faulty system to continue to bleed or more than 30 years in my case, but in another case is even longer. And then in conclusion, to heal, of course, it demands, as I say, a first step from the victims, but at the same time demand a strong engagement from the society and from the state.
Thank you very much. And we close with the intervention of Gianfranco Patuzzo Garcia, the nephew of Ramon Mauricio Garcia Prieto, who was assassinated in El Salvador in 1994.
Thank you. I'm going to keep this briefly. So my name is Gianfranco Patuzzo. I'm an MA student here at LAC, Latin American Caribbean Center. So in the afternoon of June 10th, 1994, in San Salvador, El Salvador, the Garcia Prieto Giral family changed forever, taking a turn for the worst. That day, Ramon Mauricio, my uncle, the eldest of the Garcia Prieto family, at 32 years of age, was assassinated. He was assassinated by death squads, los Escuadrones de la Muerte. After much consideration, the only possible reason for Ramon's assassination, given the fact that he did not even live in the country of El Salvador at the time, stems from the complicated sale of a plantation to General Mauricio Ernesto Vargas, a very powerful man, to say the least. Given his nature as one of the signers of the peace accords, as the representatives of the armed forces, he was given the responsibility to make sure that the government executed the peace accords successfully and entirely. From the moment of Ramon's death, the institutions in charge of carrying the due process of law, such as the police itself, prosecutor's office, the judicial branch as a whole, failed. And they failed entirely. They committed countless of incomprehensible errors from the standpoint of the truth, from the standpoint of justice, and instead opted to cover the case with a shield of impunity. Apart from the impunity that pushed towards the case, there were threats of all kinds, including death, to the Garcia Prieto family. There were always men outside the family's house, the phones were tapped constantly, properties were burned, armed vehicles chased family members. Potential calls were made during all times of the day to the house. It came to the point that even gunshots were made at the family's beachfront property while they were vacationing there. Even further, Mauricio, Ramon's father, my grandfather, he was even held at gunpoint at one point while walking the streets. The threats are massive and can amount to more than the time frame that I'm even allowed to be here. Needless to say, the family was forced to change their life and live in a sort of nightmarish reality. Without anywhere else to go or where to look at, the Garcia Prieto family, my family, we turned to Monsignor Arturo Rivera Damas, a close friend, and he suggested to seek the law in the archbishopry, and an investigation could begin from there. Given the circumstances of the assassination, he said that they resembled those carried out by death squads. Once the investigation began, the evidence from the murder had disappeared. The evidence was gone. However, proof of the death squads that they were involved was found through the apprehension of two of the men that carried out the hit. The proof was that they had left the police station. They were seen leaving the police station in the car that my uncle was murdered in, and they were seen coming back into the police station. Not just the station, but the headquarters. Apart from these two men, the investigation still called for a third man who was expected to be the driver. And apart from these men, the mastermind who had carried out the operation. The case stagnated, and going nowhere, my family opted to seek the help of the UNUSAL, the United Nations Observer Mission in El Salvador, given the fact that the peace accords had just recently begun there, and that had taken place, the UNUSAL was still there. In July 1995, the IDUCA, Institute for Human Rights, took the case, or Instituto de Derechos Humanos, where in the same year there was an abduction, an attempted abduction and multiple threats on the director of such institution. This just made the case even more of a turmoil. In '96, Dr. Victoria Marina de Aviles, the Procurator for Human Rights, was the only person in El Salvador, the only person representing any organ of El Salvador's justice, that gave the resolution dictated that the Garcia Prieto case, our case, was carried out by the death squads. This was the only breath of fresh air we had in 2 years from '94 to '96. Since this was the only institution in the country that officially made this public, it gave us at least the basis to seek further justice. On October 22nd, '96, the case progressed, and the IDUCA, accompanied by the Sigil and the family, we went to the Inter-American Commission with the case. From '97 to 2001, 3 hearings took place in which Salvadoran government representatives and my family attended. In October of '05, the Commission found that the country of El Salvador had not acted under law and under the Court of Human Rights, and therefore had officially sent the case to International Court of Human Rights. On the 20th of November of '07, finally and successfully, the court found the country of El Salvador guilty. Justice was to be sought. The court mandated the country to give the family physical and mental help and reimburses for any expenses they had endured throughout the years of the case. They also mandated for the sentencing to be published in the national newspaper, but most importantly, for the investigation of the assassination and of the multiple threats to my family to be investigated, to be continued. Like the evidence that I mentioned earlier that went missing, the mandates became missing as well, as the country of El Salvador only carried out bits and pieces of it. Here's the sad part, not only to an already horrifying story, but so disastrous was the country of El Salvador in the process that in the 4th of this month of this year, not so long ago, the court held another hearing into the investigation of the case and the death threats that the medical help provided for the family and the Salvadoran state investigations into the assassination and into the death threats had never honored its sentence. Now, it's going to be 20 years in June since my uncle's assassination. 20 years of fighting, and this case is not just a struggle for justice, but moreover a sign of hope and strength, more of a symbol of endurance, not just for my family, but for others alike that have suffered violations of human rights in any way and have nowhere to turn, not even to your own government. That's why I would like to say thank you for these institutes, for being there, because at least it gives us hope. As bad as it is, as bad as it was, it could be worse. Through these systems, we're at least able to move forward, and that's where we stand. Thank you.
Thank you very much. Now we'll open it up for, excuse me, Ana Maria.
Very small things. I would like to say that Sehil, that has represent both cases in the Inter-American Court. And then Viviana, thank you very much.
Okay. Now I think we have plenty of time for questions and answers. You can address your question to any of the presenters. I will recognize whoever wishes to ask a question, and then probably we'll collect 3-4 questions to start and see if we have enough time to go through a second round. So, questions, comments, observations?
I wanted to connect both Professor Krsticevic's discussion of, I was interested, of course, on a more theoretical level of something I hadn't really known about, which was the idea of, let me see how, moving beyond reparations to measures of non-repetition, which is a really interesting set of different ways of conceiving of justice. I'm interested in what kinds of justice, how justice is perceived, what would be a just outcome for some of these. And obviously the answers probably depend on the individual national histories or personal histories. But it also occurred to me at the very end when Giancarlos was talking about no longer looking for justice, but rather the case becoming a kind of centerpiece in which his family could demonstrate its strength in the face of what had happened to it. And you actually kind of said justice isn't quite the point anymore, but rather this is a place that we can continue and draw strength from. So I'm wondering if you could comment, either one of you, on what justice means in these kinds of cases and what other alternatives other than a sentence that somehow comes down in your favor would be satisfactory to you.
Justice and the whole process of litigating internationally is lived by different people and communities in a very different way. And so things that for some people might be empowering, for some might not be so empowering. In general, I think most persons that go through this international litigation process feel frustrated at times, hopeful at times, but they also feel empowered because generally it's not my story against your story or somebody else's story. It's an international court that says you're right and rewrites a narrative, and it's a narrative where you've constructed that narrative with the participation of the state. There's an element there of a dialogue, of due process, as we say as lawyers, where a new history is being written, and you're being validated in your experience by somebody else. Then the whole theory of reparations in the Inter-American system actually has a very interesting anecdote that helps explain it. Is the Inter-American Court, in the first decisions that they issued, they used to look at what the European Court does, and they traditionally have given only monetary compensation, but they haven't been as daring in going into other measures of what we call in international law satisfaction and non-repetition. In the mid-90s, I had the pleasure. I was very young, and I have to say I'm very young because if not, I will look like ancient. But I went with Pedro Niquen and Ligia Bolivar and Juan Navarrete. I think we went to the village of El Amparo in Venezuela, and the mothers of these villagers that had been killed by the military would hug us. And I still remember, this small woman from the border saying, she would hug me and say, no, my son was not a cow. I don't want money. I want justice, So we felt all of this responsibility as lawyers of, well, we cannot just, get a decision of this Inter-American Court that provides a narrative and money only. We have to try to look for measures of justice and other types of reparations. And so we started constructing a theory based on the letter of the law of Article 63 of the American Convention, where we distinguished, and the court started moving on these different measures of reparations that then became much more sophisticated. At the beginning, we didn't have the support of the Inter-American Commission on Human Rights, which is also party to the litigation of the cases, because, under the more rigorous interpretation of what was our model in the European system, we had what we needed to have. It was money and a recognition. The decision itself was a recognition of our rights. But then over time, family members, and in these discussions with family members and communities, and also with NGOs, because we see the cases as opportunities for non-repetition, and in that we try to think through some of the public policy measures. And then that opened the texture of reparations to acts of acknowledgement of responsibility, for example. So I remember the case of Mirna Mac in Guatemala, where President Vergé, in front of like 100 members of the military and communities from the places where Mirna Mac had worked as an anthropologist, and the human rights community asked for forgiveness. It's like those things happen because of the creativity, I think, of the family members, and because we as lawyers were translators of those needs and desires for reparations. But I think that the effect of that in different countries is still to be seen and analyzed. I leave it through the feelings and opinions of family members and NGOs, but I don't know whether those stories have been told, or if it has been studied, what is the ultimate impact of trying to change the discourse. We believe as activists that it's very powerful, but at least it's powerful to those who are there.
I don't know if Gianfranco and Ana Maria wish to comment briefly on what justice means at this point to you and your families, our families.
Just to make this short, though, it's difficult to make it short because I think the term justice itself, it's vaguely stretched out. It could also be a misnomer, it could be an incorrect term, and depending on who's using it. I'm a big advocate of that, you consider to be true depending on the surrounding that you're in. And going back to the healing process that, Dr. Bidegain was saying, the first step begins with the victims. And linking the victims and linking that first step with justice, I think is huge. Because if you believe that justice is fine where you're in, but justice is not, nothing is happening towards justice, then nothing's gonna continue to change. I think that if you unlock that and you not surround yourself with people who have just been victims and do nothing about it, but take a different approach, you do a battle, or you seek a different term for justice, then that's when something can happen. I think that's the difference, and that's what I was saying earlier, between just what justice is and what justice as a departing point from.
I think that I agree with both of you. In one way, the fact of looking for justice empower the victims in some way. But it's very painful. It's terribly painful, first of all. And after that, I think that what you look, the first is the truth. The truth is I think, is fundamental. And at the same time, that the society knows the truth, and the state recognizes the truth, and also at the same time to look for some way to change the situation. And I think if the society have this kind of awareness, then that is the possibility. And then that is the reason that I think that right now that in Colombia we are seeking a peace process. One aspect that should be very, very important, and I think that the governor recognized that, because I don't think that Semana did this gathering of the victims of the whole country was the idea of Alejandro Santos, who is I don't know if the nephew of the president. But I think that the state recognized that they cannot go in this way, and we need to change, and we do some change. Then one thing that I think that also repair a lot is the no repetition, because it's an undeserved pain that we don't want for anybody else. And the other thing that I think that is important is, of course, one issue that need to be addressed in Latin America is the role of the army. I think that is fundamental. In Latin America, we need to have a big discussion on the role of the army because many of the violations of human rights came from the army then, and that is I think it's going to be the most difficult in the case of Colombia, but also in the case of Salvador has been very difficult, and other places. But and then this no repetition is very important. I think that's, as Viviana said, I even have not realized on the monetary issues. We just discussed even almost when we were in days before to go to Brasilia, because for us the most important was to all the rest. And then what is also important for the victims is to try to make light of this life who has been lost, and the path and all that they could bring to our society, and then that is the kind of thing that, for example, I request for a scholarship for somebody else to finish what Carlos Horacio couldn't do, to finish his PhD. He was finishing his PhD in political science. Then he was a lawyer, but also he was interested in history and on other things. Then to me it's most important that Colombians could think about and not have more repetition.
Well, thank you very much for your presentations. I really think those were very instructive. I'm just curious about the way victims perceive justice in cases of human rights violations, where for example, the Inter-American Court of Human Rights orders the state to pay such and such amount, or the state to recognize such and such violation of the human rights, but they don't see the perpetrators of those horrendous crimes being punished by the law. So can the victims really have the perception or the feeling that they are obtaining justice, even though it is just the state, not the human beings that committed the crimes, and maybe it's the state even represented by people other than those who represented the state at the time of those actions, who are really paying the consequences of those actions?
Thank you. This is for recording purposes because my voice really projects. I'm an activist, so. I have to stand up and say something. I'm a student of Dr. Bidegain's. I was introduced to her story rather incidentally, just as I've gotten to know her and adore her and love her and respect her for her unending transparency in pursuing this effort. And I've been introduced to another story that's taking place right here amongst faculty and students at FIU. I'm a member of the Graduate Advisory Board, and I think it's extremely important that a wound needs to be aired. A Band-Aid usually doesn't do the work that's necessary, and sometimes you just have to expose it. And in November, I've allocated special collections for an exhibit dedicated to the memory of Jose Horacio Urang. And I invite the gentleman the student from LAC, if he wants to incorporate something about his family member, to also do it. It is the only way that reparation and healing can take place, especially where these representatives of these tragic, horrific events come and work and study and produce on a daily basis. And I hope that these colloquiums continue to happen and take place, and that these wounds continue to be aired in support of all those institutions that are helping to heal them. And that's basically what I wanted to add to this. Thank you.
Thank you very much. So now we have comments on particularly the question on going after the direct criminals.
I just wanted to clarify that even when the Inter-American system is not an international criminal court, in many cases, because of the decision of the Inter-American Court, and even if there's not like a broad change in the patterns of impunity of the country, in some countries, there are important measures in terms of punishing those responsible. For example, in the case of Fujimori and Montesinos and all, I mean, a big group of the Peruvians, the ones that were engaged in the direct disappearances in ordering and the masterminds, are in jail. And in some other cases as well, we have done some tracking of how these cases affect the judicial process, and so some of those responsible are in jail. Not all of the ones that should be in jail, and sometimes in some countries there are incredible obstacles, such as in El Salvador, where things have moved very little, or well, in Brazil or in Guatemala. So there's a lot of frustration for some of the family members, with and without justice. Without justice is enraging, because you know that that you're not equal under the law. You know, that you are a second-class citizen in a way, because you don't deserve to have, you know, some outrageous event being condemned by the judicial system. So I think it really undermines the place of a person in a society to have those levels of impunity with the type of violations that occur. But even in the cases where there is justice, and I've known many family members, there are also, you know, there are the political things and then the psychological aspects. You know, sometimes there's a feel of vacuum even when you achieve justice, because so much of your energy is sometimes devoted to looking for justice and truth. Then you achieve that, and you're like, and there's a feeling of joy, but also a feeling of I don't know, it's like a vacuum. And I've seen it, like people go through depressions, you know, through a very difficult time. So it's a very, very difficult path. And I think it would be very interesting. And we read a lot about the literature of trauma and violence, but I'm not sure how much epidemiology is there about the effects of violence in our societies. And it would be really, I think, very interesting and important for societies to understand how these events shatter, you know, societies at so many levels, no? Families, I mean, we've seen all the time how it affects the direct family members, but also in different generations, communities, and societies as a whole. So I think that's also a very important thing to look at. There's a book written by a psychiatrist actually, that did a study on reparations and testimonies of family members that had decisions before the court, and I'll give you the name, and if you're interested in what has been written about that. Thank you.
I don't know if there is another question. I want to ask, if I may, about kind of statistics, if you can give us at least a rough estimate. How many cases has the court tried thus far? How many of them are acquittals? How many of them are actually sentences against states? And what is the average time that has lapsed between the moment the crimes were committed and the moment sentences against states were issued? My sense is that here we have two examples, 20 and 28 years, and that seems like an awfully long time, and I wonder if there is any way to shorten some of these times, because it seems like a torture for someone. It's half of one's life to be waiting for resolution, and it doesn't seem to make sense.
Yes. The court has issued around 200 decisions, I think. And most of the cases rule against the state. A few cases, I would say, I don't know, a dozen cases were lost. Some of them, I think, because the court made serious mistakes, either on facts, on the law. I think that less cases should not have benefited the victims. Then there are some cases where the court has ruled and has supported some of the claims, but not all the claims. And sometimes, I don't know, there are some things that for family members are very important that are not supported by the court. So, for example, I remember very clearly the case of Castillo Páez, where the father of Ernesto Castillo was really very disappointed because the court had not, in his perception, vindicated the memory of Ernesto Castillo as a student and had not given a proper compensation. And so he felt bad about that because he thought it was like an inadequate reparation economically, but also in terms of that. And in terms of the time that it takes to process a case, that varies a lot, and it depends of many factors. But some cases can take between 5 and 15 years to be processed. The process before the court takes around 2 years, but the commission has an incredible backlog, and that backlog is not being resolved, not because there are so many cases pending before the system, but because states do not allocate reasonable resources. We did a study of the money that is allocated domestically, for example, for ombudsman's offices in different countries in the region, and what is the budget of the Inter-American Commission. That's in our website if you are interested in looking at that. But it's not that states couldn't solve the backlog of the Commission, which is around 5,000 cases. It's a question of not giving the resources because states are not prioritizing this type of monitoring. And so it is a very serious problem, but it's a problem that could be solved with a little bit of political will. But in order to have political will, we need to bring that message in different ways by different actors. Just victims and advocates for the victims are not enough. Academia has to be engaged, civil society in general, the public, the press, students.
Exactly because of how long these issues get to be addressed by the Inter-American Court, I was mainly wondering what happens when there's a pending issue that could affect certain people based on that decision, but nothing has been done yet. I'm specifically talking about the issue within the Dominican Republic and Haiti right now, where citizens were stripped off their citizenship because they have Haitian descendants. These people that are waiting now for this decision of the case that has been filed already in the Inter-American Court. What happens to them if there's any sort of protection, or what can be done, since this community tends to be so small in the whole international arena? What can be done to grant them any protections, if any?
The case is one of the lucky situations in the unfortunate decision of the court in the Dominican Republic, because actually there is a group of people domestically and internationally that are following that situation of the stripping of nationality of Dominicans of Haitian descent. And the Inter-American, there was a case that we litigated actually, Gianni Bosico, and so we are doing follow-up of Gianni Bosico. So there's a legal track of following on the case, but also the commission decided to use a range of other tools in order to follow up on that situation. So they did an on-site visit, and if you go to the website of the Inter-American Commission, there's a section on, all of the meetings that they had, and they did preliminary observations, and so they met with the president, with the members of the Supreme Court, with different organs within the executive that deal with migrants. They went to the border, they met with people and took petitions, and they did a lot of public outreach in order to show that this was a big problem and that the Dominican Republic was actually discriminating and stripping of rights to thousands of people by taking that decision. And besides that, there's a campaign going on by a group of organizations and people domestically and internationally trying to raise awareness about that specific situation. But I would say that was very unique, and it's not always the case that things can happen so, I mean, that you can mobilize so much of the resources of the Commission around a key issue such as that one. Yeah. The thing is that sometimes when people think about cases, you think about the final decision of a case. But sometimes, I don't know, we have cases where the filing of the case and hearings in the case and things like that, they create they interact with process domestically, and also the development of jurisprudence interacts with things domestically. So for example, in El Salvador, which is a horrible country in terms of impunity, there has been very little movement on impunity. But I think a couple of weeks ago, there was a decision of the constitutional chambers of the Supreme Court on the right to truth. So as I knew I was coming here, I was like, oh, I have to read that because maybe they will ask me about it. So one of the lawyers in our office sent me a little background on the decision itself, and I was reading El Faro, and that constitutional court had quoted some of the decisions in other cases that the Inter-American Court had issued that dealt with the right to truth. So sometimes there's this, I don't know, these synergies that are actually created by the development of international law and international standards that then affect situations domestically, even, or I don't know, sometimes you have a case, you have a hearing at the Inter-American Commission, and then, I don't know, 5 members of the military just, the judiciary decides to capture them, apprehend them, just in time for the hearing. Then, so sometimes there are these synergies that occur that are not documented, but we know they happen. And so it would be very interesting to actually go through that and in a much more systematic way.
It's a bit off topic, but can you comment on these alternative efforts by international community to fight impunity and bring justice using like CICIG in Guatemala, these kind of commissions in other countries in the region? Because there are efforts in Honduras, for instance, in El Salvador, have been talks of doing this kind of thing. So how these efforts relate to the work of the Commission, the court in general? How likely are they to succeed to some extent to see this kind of organization or commissions in these countries?
Thank you for this. This event. I think it's very important for a couple of reasons, not only because it reflects growing awareness on the part of our faculty and students about cases, as this gentleman, where did he go, said, but because I think it's important to understand one basic thing, and I want to comment on the Dominican Haitian case. I'm very involved in that particular case, so just a couple of things that are important. I mean, here we've listened to the story of 2 families, and we've heard from activists, and we also heard from a professor who noted the significance of political processes in countries, and also evolving jurisprudence within each country. And so I think what you have here, that unless all these stars all align themselves, you have very little progress, all right? And the Dominican case is a classic case, where you've had enormous advancement on, let's say, the evolution of the justice system there. The creation of a constitutional tribunal, for example, was seen as an enormous advancement. And it was largely the product of the Colombian example, right? The Colombian example was seen as, the constitutional tribunal was a way to overcome the problems of Supreme Courts that don't have the ability to question, the constitutionality of specific laws. And so what you have here is really kind of an interesting situation. The Dominicans are arguing that they have had all this progress by creating this constitutional court, and now they have a constitutional court decision which is unappealable. And this is what they're basically saying. The president is saying it's unappealable, and it is. If you look at the Constitution, if you look at how it's set up, it's an unappealable decision. And at the same time, they're saying, yes, we entered into the International Human Rights Court in 1999, but we never ratified it. So technically, we're not bound by the International Human Rights Court, any International Human Rights Court. And by the way, as the professor from our law school said, the United States and Canada aren't signatories anyway, right? They haven't even ratified the UN Declaration of Human Rights, and yet the court sits in Washington. So, why should we be forced to follow any of this stuff if even, the guys where the court is sitting don't follow it? So what I'm saying is, in the Dominican case, I think what has advanced it more than anything else has been, one, pressure from outside, but yes, the court, I think, has played an important role, but it has been extraordinary activism and the role of the media in particular. So I think unless you can really align all these factors, you are really overtaken by domestic political events and sometimes these unexpected results of evolving, whatever you want to call it, jurisprudence domestically. Okay?
In terms of how change happens and what explains how you move an issue, I think the alignment happens differently in different contexts and topics. And that's one of my challenges to you as academics. I read many of the things that are written on how to explain this, and I think it varies a lot. You cannot explain Peru in the same manner that you explain Colombia and what's happening in the Dominican Republic, and I think, but I think there are many things that can be said by analyzing some of these cases comparatively, and one of them has to do with embedding some of international law and human rights in institutions and frameworks and procedures, but the other one, maybe, I don't know, and this is probably, your activist side and my activist side, it's like if the media, if there's not a discussion domestically that puts pressure, then it's very difficult to move, to actually make sure that some of these decisions are enforced, or that the decisions can contribute, beyond compliance of the decisions, but the decisions can contribute to a society moving in the right direction in terms of the protection of human rights. And in terms of El Salvador, I'm not sure whether I recall the whole question. The CICIG. Yeah, I love that. CICIG, the CICIG experience. I think it was fantastic in terms of impacting the development of the institutions, and specifically the public ministry and the fight against organized crime in Guatemala. But it also reveals what is happening right now in Guatemala specifically, that you're probably very much aware, with the early shortening of the mandate of Claudia Paz y Paz, reveals that the powers, the de facto powers in many of our countries are still very undemocratic, and that there's so many deficiencies in in the rule of law and institutionalities. I think that some experiences such as CICIG and the synergies that that can create with the UN system and the Inter-American system and local actors that are pro rule of law, equality, and justice is critical for overcoming some of the problems. There have been discussions about doing a CICIG for the Northern Triangle, and I think there are different models that can be used, but I think in general, I see that those experiences as valuable because the reality is so deficient. I think at least in that experience has been helpful, and if something like that could be replicated, probably with different powers, or it has to be rethink how you do it, how you would do it at a sub-regional level, or for Honduras specifically, then it might be important. I think that unfortunately, some of the most basic things that are revealed through the human rights cases are the deficiencies on equality under the law. I always think it's like a luxury and a dream to think we are all equal under the law and have rights. That's the basic thing, and I think that institutions like that can actually make a difference. And so can, with all the deficiencies, and this is why I was starting with the bittersweet thing, because I know that it cannot solve all of the problems, but maybe it can create some of the synergies, and it could be better if there was more engagement from different sectors in pushing for that to be more effective.
Thank the Latin American and Caribbean Center and its Andean Studies Program, the Václav-Havel Initiative for Human Rights and Diplomacy, both of which are LAC and the Václav-Havel Center, part of our School of Public and International Affairs, and also thanks to the College of Law for having participated. Thank you very much.